Number 3 in the name of Dr. Russel Norman.
Mr. Speaker.
Dr. Russel Norman.
Mr. Speaker, my question is to the Minister of Justice and asks, does he stand by his statement in this House on Tuesday the 10th of February 2009 that, quote, "This government is committed to access to justice for all, not just for those privileged few," unquote? And if he does stand by this statement, why?
The Honourable Simon Power.
Yes, access to justice is important for all, none more so than the least privileged in society.
Mr. Speaker.
Dr. Russel Norman.
Thank you, Mr. Speaker. Did his own Ministry of Justice provide advice that the government's proposed changes to the Resource Management Act would present an obstacle to taking a case to the Environment Court for those people with legitimate cases but not enough money, and is that justice for all?
The Honourable Simon Power.
Mr. Speaker, as I'm sure the member is aware, I'm not responsible for the planned amendments to the RMA. However, I'm advised that the Ministry of Justice was consulted on the proposed bill, and in the course of the consultation they were satisfied that the issues around access to justice have been addressed.
Point of order, Dr. Russel Norman.
I was asking about a specific piece of advice from the Minister's ministry, and I'm seeking whether his ministry provided a specific piece of advice, and I would ask the Minister to address that question.
I think the member has further supplementary questions. I think he's being a wee bit too asking a bit much there. I invite the member to ask further supplementary.
Okay. Did his own Ministry of Justice also advise that limiting appeal rights under the Resource Management Act would take away a fundamental right of New Zealanders? And how is taking away a fundamental legal right to appeal district plans to the Environment Court consistent with his commitment to justice for all?
Mr. Speaker.
The Honourable Simon Power.
Mr. Speaker, advice was provided in respect of the bill, and I'm advised that the Ministry is satisfied that any issues that member raises have been addressed.
Dr. Russel Norman.
Thank you, Mr. Speaker. Does he agree with his ministry that when you impose a cost on people's access to justice, that there will be a group in our society who will no longer ever have their day in court, and that group will be ordinary New Zealanders trying to fight corporate developers whose legal costs are actually tax deductible? Does he agree with his ministry that when you impose those costs, you restrict access to justice?
The Honourable Simon Power.
I agree that costs and their relationship to access to justice has to be measured carefully, and to ensure that the justice system provides as many people as possible. And that's why I'm confident that the Resource Management Bill, which will be tabled in this House at some stage in the next few days, reflects those concerns in a proper and appropriate manner.
Materia Ture.
Thank you, Mr. Speaker. Is the Minister aware of the key findings of the 2006 TPK report, Māori and Council Engagement under the RMA, that there is low-quality Māori participation in RMA processes? Most Māori groups cannot compete with professional planners and lawyers, and basic costs stand in the way of Māori access. And how does he then expect Māori to engage with the Environment Court process if, in addition, they have to lodge a bond just to get a foot into the courtroom door?
Mr. Speaker.
Honourable Simon Power.
Mr. Speaker, no, I'm not aware of that TPK report, but I can assure the member that any issue relating to security for cost, which I believe the member is referring to, is a matter which is a discretion, and that at the point that those orders or requirements are made, genuine cases are considered where a plaintiff may have limited means.
Dr. Russel Norman.
My question to the Minister of Justice is he aware that before the power to award security for costs was removed from the Act, powerful applicants were using that provision to intimidate community groups, threatening to bankrupt them if they exercised their legal and democratic rights to object? And how does putting security for costs back improve access for justice?
Mr Speaker.
Honourable Simon
I'm
Power.
going to answer the second part of that question. I'm advised that there are adequate safeguards such as fee waiver provisions and the discretion of the court to not require security for costs, and I believe that issue addresses the member's question.
Dr Russel Norman.
Thank you, Mr Speaker. Why won't he simply admit what his officials have advised him is true, that the changes National plans to make to the RMA will limit access to justice for those with limited money? And if you don't have the money to even get through the door of the courtroom, you will never get access to justice in Aotearoa, New Zealand, under a National-led government.
Mr Speaker.
Honourable Simon Power.
Mr Speaker, I'll admit no such thing. I will restate what I said earlier, that is, I am satisfied that those issues of access to the Environment Court, through mechanisms around discretion of security for costs, for a new structure of filing fees, which would in fact make the application of those fees and daily hearing costs probably cheaper than the District Court and High Court provisions as they currently stand, is sufficient, as is the advice that has been put into issues around the new RMA legislation to ensure that access to justice issues have been addressed.
Point of order, Materia Ture.
Thank you, Mr Speaker. I seek leave to table a document, a page from the TPK report I referred to earlier, setting out the key findings showing Māori are restricted in their access to resource management processes, primarily due to financial restrictions.
Is there any objection to that document being tabled? There appears to be no objection.